Thank you so much for joining us this evening. I'm Rachel Marks. I'm affiliated with the law firm of Schonfeld Goldring, and I'm the Vice President of Shalom Task Force. Joining me this evening for this important webinar is Erin Bistricer. She's a senior staff attorney at Sarah's Voice. Sarah's Voice is a legal branch of Shalom Task Force. And tonight we're going to be talking about litigating while chained, the coercion of the Agunot. An Agunot is a chained woman who's being refused a religious divorce. Before we jump right into it, I had a really encouraging experience this week. As part of my involvement with Shalom Task Force, I give some of the educational programming. I present some of the educational programming. And this week I was in two different schools, a boys' school and a girls' school. And while presenting and educating about domestic abuse, after discussing physical abuse, which is often the most obvious forms of abuse, I threw the question out to the class about the boys' school and the girls' school and said, can you give me some examples of other forms of abuse? And for the very first time ever since I've been doing this in both schools, one of the students, raised their hand. Actually, in one of the classes, two students raised their hand and said the same thing: refusing to give a get, or get refusal. Isn't that incredible? Over the past, in recent months, there's been an incredible movement. Attention has been given to the issue of get refusal. And to see high school students, young men and women, acknowledging get refusal as not only a form of abuse, but the second form of abuse to come to mind immediately after physical abuse is really encouraging. And I dare to say it's a sign that we are moving in the right direction, that things are going to be changing, that the hard work that people in the field and the community at large is really beginning to pay off. And through this kind of acknowledgement, I'm excited to see change and hopefully, new and better things, and the freeing of many Agunots. So with that, let's jump into it. At this time, I'd like to introduce Erin Bistricer again. She and I have done a number of webinars over the past year. It is always a pleasure to be sharing the screen with her. She has been with Sarah's Voice since 2012. Erin is passionate about bringing awareness of domestic abuse-related issues to the court system and works zealously on behalf of survivors through a combination of litigation and negotiation to secure outcomes that meet her clients' needs. Good evening, Erin.
Good evening, Rachel, and it's a pleasure for me to be joining you as well. I think we're at our year anniversary of doing these webinars. One of the positive things to come out of COVID is having a platform where we're able to speak to people more easily. And I echo your sentiments about your story when you told me this evening. I got really excited to hear that that's how they identified abuse, because for so many years I'd be hearing feedback from friends, from family, on social media, when I would see get refusal coming up, and the idea of, well, there's two sides to every story, and isn't there certain circumstances where get refusal could be used as a way to prevent maybe exploitation on the other side for some reason, and there could be times where it's justified, but we've always defined within Shalom Task Force get abuse as abuse. The refusal to provide one is a form of domestic violence that we've been trying to educate people about, which was really the brainchild for this webinar. So to hear that the message is growing, and especially among the younger generation, which will continue the work, that's really encouraging. So thank you for sharing that.
It really is. And as we know, we do a lot of education on Shalom Task Force with the goal of prevention. Of course, we also have a goal, we provide support and, intervention in our legal department, but education is so important. And if, to hear students say that, we know that our message is really coming through, and that's the way to eradicate these issues. Okay, let's jump into it because we have a lot to cover tonight. So we know, as we just said, of course, there's been a lot of attention to the issue of Agunot and get refusal. But let's take a step back and really define some of these issues and see how we get to this point. How does somebody become an Agunot? What legal processes do they have to go through? And so let's first turn to that. Tell us, Erin, a little bit about the Beit-Din process and how that might intersect with the civil courts.
So a lot of times when we talk about get refusal, it starts from the beginning. The couple separates, and the wife can, and I'm going to use the word wife because that's the most common form of get abuse that I've seen, though I've seen cases where it's the wife refusing to accept a get, but for the purposes of this webinar, we're going to talk about the wife who is being refused the get.
And if I may interject for a second, just to make it clear, a get has to be given by a man and accepted by a woman. Okay, that's how a get is effectuated. So if a man refuses to give a get, obviously a woman cannot receive it. If a man wants to give a get and a woman will not receive it, that would also result in a situation where a get has not been effectuated. However, the remedies are different, okay? And that's something we're not going to get into tonight, but unfortunately, remedies that may be available to a man are not available to a woman under halacha. And we'll leave it at that, halacha being Jewish law. We'll leave it at that. That's a whole different conversation. Go on.
So the way the process is supposed to start is that, either the man or the woman can request what I call a get ceremony. It's when you essentially have a rabbinical court convene to issue the get from the man to the woman. The husband can request one and the wife can request one. So what you're having essentially is this process where you're going to a beis din. A beis din is a rabbinical court. And you can give the rabbinical court authority to do more than just the get. You can give them the authority to decide a whole host of issues on your case. And that is what we refer to as arbitration. Arbitration is essentially when you ask an impartial adjudicator, which is not the civil courts being a court that's run by the government or the state, the city, which is not within the Jewish community. It's like I said, it's secular. And if you don't want to go to a secular court, you do have the option to have someone else make decisions for you. That process, when you're having someone else make decisions for you, is called arbitration. And as we'll discuss later on in our webinar, arbitration is often binding. The way that you start arbitration is that the parties have to sign something called an arbitration agreement. I'm going to get to that in a minute, but it's essentially a document, and this is a sample from the Beis Din of America. It's just that you're allowing the arbitrator to make decisions on your case. So what we see a lot of times is that you have to go to a beis din to get your get. What might happen when you go there, not in every case, is the other side might say, I'm not giving you the get unless you make certain concessions or unless you agree to go to arbitration, and give the beis din now not only the power to do the get, but the power to do things like custody, child support, distribution of your marital assets and debt. So you can give the arbitration process a lot more power than just the get. And this is where we kind of see get refusal starting to pop up, is when one side, yeah, Rachel, you're going to say something.
Sorry, for clarity purposes, I also want to explain the difference between mediation and arbitration.
Yeah.
Okay. Mediation is basically settlement negotiation between parties and mediator. Sometimes there may or may not be attorneys involved. It is not binding. Okay. It is not binding until there's actually a signed agreement between the parties. On the other hand, in arbitration, you're signing an agreement, the agreement that Erin was just showing you, that gives the power to the arbitrators to make decisions for you, essentially making them judges, okay, giving them the same kind of power that a judge would have. You would present a case to them, they would hear a case, they would decide a matter. Also, in terms of the get, it is possible, and it's often done just to go to beis din to take care of that get, to effectuate the get.
So with the sample agreement that I pulled up, because I really like the way that the Beis Din of America does this, if you look at this paragraph over here, Roman numeral 1, and this is giving the Beis Din of America the power to do your get, which essentially means if, they're going to decide that if there's a couple that shows up and they need to do a get, it means that the husband gives the get to the wife. Now, if you look at section 2, which is bolded, this is optional. You don't have to sign this. If you leave this blank, it doesn't go into effect. This is opting in to give the Beis Din of America the authority to make other decisions on your case, like custody and financials. Now, not all Beis Din agreements are this conspicuous. It says optional on the side. Some of them, it's stuck in there in block language. You can't even see that it's in there, which is why we always say you have to be careful with what you read before you sign it. like Rachel said, arbitration is only binding if both parties agree to it. That is one of the major differences with civil court. With civil court, you don't need consent. One party files and that starts the case. You serve the other side and they don't have a choice. If they don't show up, it's going to go ahead without them. The arbitration, both parties need consent. So what I often see in my cases is situations where someone says, my husband is trying to force me to go to a basin. I don't know how I feel about it, but what he said to me is, if I don't do this, if I don't give my consent, which he needs, I won't get my get. So that is one form of get refusal that we often see. And I already, again, the arbitration agreement is essentially the document that you sign to give the arbitrator the authority to make decisions on the case. And the question I often get is, should I sign one? And when should I sign one? And why should I sign one or not sign one? And, that is a very fact-specific question. There are times where I would advise to sign an arbitration agreement. There are times where I'd advise not to sign one. But I think the takeaway that I want you to have today is, do not sign one without speaking with an attorney. Don't sign anything when you go to a get ceremony if you don't understand what it is. You need to read it, make sure you understand it, because it has such powerful implications, because you're giving this judicial authority right to make decisions on your case. You definitely want to speak with a lawyer about what that means and what your options are, so you can make an informed decision.
When receiving a hazmana, we have to speak about a hazmana, an invitation to appear in Beit Din. Unless you're both appearing on consent, you both, you've spoken to each other, or your attorneys have spoken to each other and said, okay, let's go to Beit Din, let's take care of this. And then you go through an arbitration agreement. There's often a hazmana, which is an invitation, a summons to appear in Beit Din for the process. And the Beit Din would send that to the party. Okay, one party would approach the Beit Din and say, I would like to take care of this process under your jurisdiction, take care of this divorce under your jurisdiction, and then the Beit Din would send a hazmana to the other party. Okay, it's important that the other party reply to that hazmana. Speak to an attorney, speak to a rabbi, speak to somebody who's familiar with the process to get advice on how to proceed. If you don't respond to a hazmana, then a second one will be issued, and then a third one if you don't respond. Okay, and this is the path to a seruv. In between three hazmanas, there should be a warning before there's a seruv, but this is the path that gets you there. So it's really very important to reply to that hazmana, even if it's to say, I'm not comfortable and you suggest something else. But after receiving that hazmana, it is important to consult with somebody who is knowledgeable in halacha and Jewish law and in secular law as well, to see how this process may affect your civil divorce.
Yes. And I think, this process is a complicated one. You should certainly be consulting with people who understand the civil courts and the Beit Din. It's not just one. And part of where we see get refusal come in is really just one side gets the hazmana, the summons, and they respond with a different Beit Din. Now they can't choose the Beit Din, and they're stuck. And if you can't choose the Beit Din, you can't have the get. So then there's a lot of negotiations that go on behind the scenes to see if there is a Beit Din that both parties can agree on. And again, the reason normally the parties are fighting over which Beit Din to go is not necessarily because of they're concerned about which one is going to give them the get. It's because they're concerned about all that other issues, about whether or not they're going to give the Beit Din the authority to decide other issues on their case. That's really where you see the fight come in. So I want to move towards, kind of more about what the Beit Din process looks like. Once, let's say you are thinking about signing an arbitration agreement, what that looks like, and why would you decide to go to a Beit Din rather than a civil court? So there's a lot of, just to start with, this chart, as you can see, it's a little confusing. It's because Beit Dins can do certain things and civil courts can do certain things. And the decision on which one to go to might depend upon what you actually need. So if
Erin, I'm going to stop you because we forgot to give our caveat that we give at every webinar, and often don't remember until the middle. We are talking about New York State. When we're talking about Supreme Court, or we're talking about the civil courts and law, we are talking about New York State law. So if you do not live in New York, make sure to consult with attorneys in your own jurisdiction. Go ahead.
Thank you, Rachel. I always forget. You always remember.
As do I.
So as you can see here, what you have on the left-hand column is all the issues that would need to be resolved before a party can receive a divorce. And there's certain things the basin can do and certain things that the civil court can do. And then there's certain things that both can do. Notably, the order of protection, a basin cannot issue one. This is a court order saying you need to stay away from someone or refrain from certain kinds of behavior that if you violate it, you can then take to the police and enforce it. A basin cannot issue that order. This is one of the biggest considerations we take into account when we're dealing with domestic violence cases. If someone needs an order of protection or has an order of protection, basin might not be the appropriate forum. It might not be safe for the client to arbitrate in a basin. Conversely, the religious divorce can only be done in a basin. So, when we have an issue with the get and there's an order of protection effect, we make sure that the client is going to a basin that understands what an order of protection is and is not going to have the parties in the same room with each other when the get ceremony is happening. The issues such as a civil divorce, basin can't or issue a civil divorce. Only the Supreme Court can issue a civil divorce. So that's something that we're going to talk about later as why would you want to go to a civil court versus a basin? Only if you are civilly married, you can only get a civil divorce from a civil court. There are obviously issues that overlap: custody, child support, temporary maintenance, distribution of property. These are things you can do in a basin in addition to the Supreme Court of the civil courts. But sometimes they are subject to review, which we'll talk about later. So obviously this is complicated. You will always need, I think the takeaway from this chart is you will always need a combination of the two forms for the religious needs and the secular needs.
Erin, a common question that I get, and I'm sure that you do as well, how about a couple that was only married religiously? Okay, they had a wedding with papa and a religious process, but they never filed the paperwork. They didn't file for a marriage license. They don't have a civil marriage. Do they need a civil divorce? We know they need a religious divorce. They need a civil divorce.
Yeah, I would like to hear your thoughts on it as well. So what I always say is, first, religious marriages in New York are recognized as binding marriages. So if you wanted to file for a civil divorce, even though you are only religiously married, that is fine. You are entitled to all the protections of a New York marriage, even though you were only religiously married. That might not be true in every single state, but it's true in New York. Second is, do you need it? And I would say best practice is to get it. Whether or not you need it really, I think, depends on your case, the facts. If you have documents, like you file joint tax returns together, you have benefits together, if you have documents putting you as husband and wife that's in front of a civil government, I say the best thing to do is to officially dissolve that marriage, because you can kind of now have formally written civil documentation saying you are no longer married because the government believes that you are married. If you don't have any official documentation together, should you get a civil divorce? My answer is still best practice is yes. Do you need it? Technically, no, you don't need it, but I think it's best to have it, because especially in abuse situations, you never know when someone's going to come out of the woodwork and say you guys are still married. So one of the biggest important factors of a divorce is that it cuts off the accrual of marital property and debt. So I always like to have a definitive date where someone files for a divorce and you're like, okay, this legally is the end date. Now we have it official. Whereas with a religious divorce, there's no documentation that really a secular court can understand. I just think it's safer to do it. What do you think, Rachel?
Absolutely. I couldn't agree more. I don't even have anything to add, Erin. You hit the
We're on the same page.
Absolutely. It's very important to do.
Yeah.
Yes. Okay. That's my short answer. Let's move on.
So Rachel, chime in if you think of anything that I'm not covering. The differences between why would you go to a basin, let's say if you're only religiously married,
again, to be clear, you have to go to a basin to get that get. So right. When Erin is asking why you would go to a basin, she means to address other issues. At the end of the marriage.
Right. So a lot of times I get people say to me, like, look, I hear you're saying best practice is to get a civil divorce, but I really don't feel comfortable in a civil court. Why would I even want to go to a civil court if I could just go to the basin? And vice versa. I had people say, look, I am civilly married. I will have to get a civil divorce. Is there any reason why I should consider my husband's proposal to consider a basin if I want to get my get? And the reality is that these forms are very different. They each have their pros and their cons. Today I'm going to focus more on the Basin pros and cons. Civil court also has pros and cons, but given that we're talking about the religious sphere, I'm going to focus on the Basin. The obvious answer is a Basin is more religiously competent. If you're talking about issues that deal with religious law, like what religion the children are going to be raised in, things like the holidays, things that are communally specific, the Basin will understand those issues a lot better than a civil court. Some judges in civil court get religious issues better than others, so it's luck of the draw. Whereas if you go to a Basin, you know that you're going to somewhere who is versed in halacha. I also found in my experience, the Basin is a bit more flexible in terms of scheduling, working with the parties, giving people space to tell their story. In civil court, a lot of things move quickly. The judges don't give you a lot of time. The Basin is more problem solving. Let's talk it through. It could be potentially cheaper. In civil court, there are some times when you can get a free lawyer, but not always. And you can't get a free lawyer on financials. So if you have a case with really complicated financials, the Basin will likely be cheaper for you. And it's just better equipped to deal with the get. There are a lot of constitutional issues, which we'll talk about later. The civil courts cannot order a party to give a get. That is a violation of church and state, which is you cannot combine religious doctrine with civil law. The Basin is a religious institution. They don't have to worry about that. They can tell a husband, give a get or we're going to hold you in contempt. While they cannot force the get, they can say, if you don't do this, we're going to issue a seirov against you. So civil courts don't have to have that consideration, whereas a Basin did. So if the get is really the number one priority, the Basin might be a good avenue for that. Now, moving on to the drawbacks. The Basins are not always, I think the one lesson is not all Basins are created equal. There are so many out there. There's some that are specifically created for an individual case. They get rabbis or dayanim, which are judges, together. And they come in all different shapes and sizes and reputations. It's kind of buyer beware. Make sure you know what you're getting into. With civil courts, yeah, there's different jurists. You might get different outcomes depending on your judge, but you kind of know what you're getting into. There's no surprises, like who's on the bench and you kind of get a sense of how they rule. And they're all guided by the same kind of law. Basin can take into account a lot of different kinds of law. They can take into account different types of interpretations of halacha. And they have different attitudes and biases. So you really need to know the reputation of your Basin before you agree to go to one. Another
devil's advocate there, Erin. Yeah. Of course, judges in civil court each sit on the bench with their own biases, preconceived notions, and experiences as well. So, while which jurists are, in your jurisdiction and who you could possibly get, you cannot choose your judge there.
You cannot.
Okay. In Basin, though, you do have, some flexibility if you are working together with your spouse to choose a Basin together. If you cannot agree on a Basin, there are processes such as a zabla, where a Basin is constructed for you. And then in some batei din, in many actually, specifically the Beit Din of America, which we discussed a few minutes ago, dayanim are chosen based on your case. It's not always just, which three rabbis or judges, dayanim, arbitrators, come up in the lottery, picking a name out of the bag, but dayanim are selected based on what's needed in a case. So if they're going to be looking at custody and issues related to children, they will put a dayan on that panel who's equipped to deal with that. A mental health professional, somebody who is professionally trained in that area. If it's a complex case financially, they will probably have somebody on that panel who may be an accountant or somebody who is, really understands financials and finance as well. And so those are just some examples. Dayanim, are selected to be able to best decide a case. Right. But that's not every Basin.
And that goes to the flexibility point, is that one of the Basin's pros is that they can be a lot more flexible, kind of more specialized and tailored to your needs, but not always. With civil court, it is true, you get different judge, different outcomes, but the level of variety is so much more focused than there is in a basin. Like there are just so many basins out there. You just really need to know do your research and know what your forum is. And I think another issue with the basins is you need both parties' consent. Like I said, we get situations where one party wants one basin, the other party wants a different basin. Well, you could do the Zabla. It's not always recommended if you don't trust that the Dayan from the other side will stay throughout the proceedings, or we've heard of cases of Dayanim walking off. So you just have to you need to kind of choose a basin that you think that the other side is going to consent to. And a lot of times the other side is not going to consent to a basin that you might want, because they might think that that basin is biased in some way because you're picking it for a reason.
Absolutely. And that's where we have some abuse of the process issue coming up, playing games to try and manipulate the system to choose the basin that you think is going to be perhaps best for you, and not accommodating at all to the other side.
Exactly. And that's what brings us to the next point, is flexibility. The exact benefit that you have in a basin, the flexibility, the reason why I might like the basin so much can be abused by the other side, because they're so accommodating sometimes of the parties. They're flexible. They can be a little bit laid back. It also means that maybe one party who's not acting in good faith will just drag it out. And in court, there are standards and goals. You have to hit certain guidelines. You're supposed to submit certain documents by certain dates. Doesn't work as easy in practice, but at least there's this guiding principle. You kind of know what you're getting into. The basins don't have any, depending on the basin, depending on the basin, they might not have something as formalized as what the courts have to keep the case on track. So it is very much, it could, in certain cases, drag out. If you have a temporary order from a basin, it's usually, it's not a court order. So if you need to enforce it, let's say the other side is not abiding by your temporary order, how do you enforce that? It's not like you can take it to the police. It's not like you can take it to a judge right away. It's up to the basin to enforce their own orders. And some basins don't have the capacity to do that. There also could be a lack of resources. If you have a very complicated custody case, they don't have an attorney for the child they could appoint to the children to speak to the children and get their point of view. They might not have a forensic. They might not have access to supervised visits, which the basin can have. So, which the civil courts can have. So, especially when we're talking about domestic violence cases, what I often see is that there are limitations with the basin to fit the specific needs of what a domestic violence survivor might require, because they need more resources and more safeguards. The basins cannot always provide that. And at the end of the day, if you're civilly married, you always have to go to civil court.
Right. And for these reasons, custody, as you have here, custody and child support, more so custody, may not always be binding. So even if you have a decision in a basin, there is a possibility that it could be overturned by a civil court.
Yeah. Which is, leads us to perfect segue. Are arbitration agreements even enforceable? And the short answer is,
Erin, agreements or decisions or both? What are we talking about?
Both. We're talking about both.
Okay.
And the short answer is usually, but not always, which I know might sound really confusing. So let's break that down. The basic principle is an arbitration agreement by law is looked at as a contract. So if you sign an arbitration agreement and then one side says, I don't want to go to arbitration, this is a violation of church and state because you're making me go to some religious institution I don't want to go to, the courts will kind of say, too bad, so sad, you signed a document, this is a contract, it's not a religious principle. This is actually a secular principle. Just like the way we would enforce any contract, we're going to enforce your arbitration agreement. So you have to go to a basin. Now, are there exceptions to that? Yes. And that applies not only to the decisions that come from the basin, but the parts of that arbitration agreement that you signed. So like what we talked about earlier, you can opt in for child support. You can opt in for custody. A very normal phrase that I see sometimes is something saying, all marital disputes, which means the whole kitchen sink. So if you're challenging your arbitration agreement or the decision, the court will say, most of the time you have to go to the basin, but there could be an exception. The biggest exception is custody. In Brooklyn, this is second department, so it could be different if you're outside of Brooklyn, but most commonly, what we see in the second department, which also covers, I believe, Rockland County, is that the civil courts are always going to be tasked with determining what the children's best interests are. So even if you say, I'm giving this basin the power to decide custody of my children, and then someone else comes in and says, I don't think this basin should be doing that, the civil court will most likely agree with the party challenging that clause in the arbitration agreement, or challenging a decision that comes from the basin saying this party has custody and the visitation is going to look like X. The civil courts say we always have final say on what happens to the children.
Really very important to keep in mind when deciding which issues you want to adjudicate in a basin.
Yeah, I mean, the sad thing is you can spend a year or two in the basin having a custody decision and the civil court could just overturn it. They might not always, but they're going to a second glance. You know, there's a possibility you could have been wasting your time in the basin because a civil court can just come in and says, I'm just going to have my own hearing on this. It really would depend on your jurors to see how much deference they would give to the basin.
Absolutely. And just reinforces that, you know, you have to go into a basin and sign an arbitration agreement eyes wide open. You have to know exactly what it is that you're agreeing to and what repercussions it might have.
Yeah, 100%. And that's why also knowing the reputation of a basin is important, because a basin that does a more thorough inquiry into custody might have a better shot at getting approved by a civil court than a basin that has a less of an in-depth inquiry into the children. The second exception is child support. So a guiding principle usually with arbitration agreements is that when you're talking about anything not involved with custody, like financials, it's just like any other contract that the civil courts are going to enforce. But because child support deals with the children, it's kind of in this in-between zone. Is it custody related? Is it financial related? And the answer is it's both. So what the courts will essentially do is, if the child support that is ordered is not in compliance with New York law, which we call the CSSA, the Child Support Standards Act, if it's not in compliance with how child support is supposed to be calculated, they will throw out the child support decision. They might not question how the basin decided whose income was what, but they will throw it out if it's not detailed enough and if it's not in compliance with New York law. And they could go a step further, actually. In the case that I'm citing here on the slide, they actually threw out everything because they said that the child support decision impacted all the other financial decisions, like if there was going to be maintenance and how the property was distributed. And because they felt that all these issues overlap, they threw out the whole thing. So while normally you can give a basin authority to decide things like maintenance, decide things like, which is support from one spouse to another, decides things like distributing the property and debt, which has nothing to do with the children. Ultimately, at the end of the day, what you can see is if the basin finds that, sorry, went ahead. The basin finds that this is just bad policy that affects the children, they can throw it out. So this is, again, just not to sound like a broken record, this is why you want to know that the basin you go to is going to do a thorough job, because the civil courts will kind of always have another bite at the apple. The standard for overturning a financial arrangement from the basin is way higher than a custody arrangement, but it still has to make sense, especially if the parties have children together. If the parties don't have children together, it's more likely that, or if they have adult children, it's more likely than not that anything financially decided by the basin will stand unless it's pretty egregious.
Absolutely. Okay, let's refocus now, Erin, back on specifically the issue of the get. So let's say a couple goes to basin, okay, and a husband is asked to give his wife a get and he refuses to do so, okay? Or let's say a wife would like to go to basin to get her get and a husband refuses to participate in the basin process, right? So we have two different things. Either they participate in the process and then he just won't give the get, or you can't even get him to participate in the process. So now we have a woman who is chained, who is asking for a get, whose hands are tied. What remedies, if at all, does the civil law have to offer her? Is there anything that she can do in civil court?
So there are remedies in the civil court, but they are, as we'll discuss, they're limited. They can be powerful when they work, but they also can be, because we have this concept in New York, not just New York, in the whole United States, of the separation between church and state, the civil courts only have a limited amount of options that they can do to kind of not force a get, but to persuade a get to be given without making it something saying to the husband, you must do this, because then they're getting involved with religion and they cannot do that. And they can't even do that halachically. So, so the New York legislature, in my opinion, is actually quite progressive in trying to address this issue. But there's only so much that they can do. And I just want to take this opportunity to give a shout out to our amazing legal intern this semester, Melissa, who did so much research on this and which we used for these slides, and was a big help in putting this together. And also I want to give a shout out to our amazing paralegal victim advocate who put the slides together. So just a brief hi to them and thank you. So the first GET law, this is the one I think most people know about. This is called removal of barriers to remarriage. This applies to any divorce case that you file in New York. And what it essentially says is the plaintiff, the person who filed for the divorce, regardless of that person's gender, needs to remove barriers to the other party's remarriage. What this means is if the plaintiff is a man, he needs to give a religious divorce to his wife if he wants to get his civil divorce. And if the plaintiff is a woman, she needs to accept the religious divorce if she wants to get a civil divorce.
And it's not just about Jewish divorces. This is about barriers to remarriage. So other religions that also have religious processes to getting divorced, they would also have to show that they have removed barriers to remarriage. It's not a religious thing. It's not a Jewish thing. It's about making sure that there are no barriers in place, that nothing else is needed besides a civil divorce for these parties to move on and remarry.
Yes. And the reason they did that is because what was happening is that a recalcitrant spouse was going for the civil divorce, getting civilly divorced, and then keeping their spouse chained to them religiously, and that didn't sit right. So the legislature in New York essentially said, if you want to get civilly divorced, you can't have your cake and eat it too. You also have to give the religious divorce. So that's the first GET law. That was passed in the 1980s, I believe, and it's been on the books for quite some time. The second GET law,
Erin, regarding the first GET law, what that practically means is that there's an affidavit that has to be signed by the plaintiff that says that they have removed barriers to remarriage. A plaintiff is the party that initiates the divorce.
Right. And if they sign that document, which they have to do to pursue their divorce, and they don't give the GET, they're now going to be held in civil contempt. Civil contempt can mean jail time. It can mean financial fines and penalties. So it could just mean you just look really bad in front of the judge, which could impact how they're going to decide other issues in your case. So it's not good to be held in civil contempt. So this is a really great way to essentially really persuade someone to provide a GET. They don't really have a choice with the plaintiff in a sense. Now, we're talking about the plaintiff. What if the chained spouse is the defendant? Do they have any remedies? Sometimes. So the second GET law was passed to essentially, deal with a case where, cat's out of the bag. If you're the plaintiff, you have to give a GET. So what I see a lot of times is husbands don't file for divorce. In my cases, like I would say 90% of the time, I'm the plaintiff because they're not filing. And we might need the court to get involved. So we're going to be the first to file. Do I have any remedies if I'm representing a plaintiff wife? The answer is yes. There's a second GET law. It's codified in 2 separate places in the law, and essentially means that when there's appropriate facts, the court can take into account refusal to provide a GET when they're deciding issues that are financial, such as property distribution, debt distribution, and post-divorce maintenance. We've even seen case law, though I didn't include it here, which is saying that GET refusal also impacts the children. We take into account when we're deciding custody because it can create a very tense situation in the household. It can impact the children. So even in custody, they can take it into account. But the areas that we mostly see it is in maintenance, like I said, support from one spouse to the other, and property distribution. Now, there are limitations to this. Like I already said, the first GET law only works when the Agunot is the plaintiff. The second GET law doesn't really work when there's no money. Like if you have no property to distribute, or if both parties are low income, it's not really going to help to say to a spouse, you're going to have to pay all this maintenance when they have no maintenance to pay. So it's not super effective in the low income cases. And also, the second GET law in particular has been constitutionally challenged in the courts. It is still an active, I would consider an active area of law that's going to be litigated. It's so far being played out mostly in the trial level. There are higher court decisions that have found that this is constitutional. It is just a factor that the courts are taking into account. But there is some pushback on it, that this is, the argument is that this is taking into account a religious doctrine when determining a civil issue. So there is some constitutionality concerns about the second get law, which we're going to see play out, I think, in years to come.
On the other hand, I want to just discuss for a moment the rationale behind the second get law and how that works, and how it wouldn't be concerned, it wouldn't be considered a forced get. Because if you think about it, let's think about what happens if somebody refuses a divorce to someone. If they refuse to give a get and refuse a religious divorce, then those people are still married. Yet they aren't living together, they aren't in a relationship, but what the husband has done is he is preventing his wife from moving on. He is preventing her from getting into a new relationship, to forming new financial partnerships. So what this law is basically saying is that if you are not going to allow her to move on and be free, then you essentially have to continue to support her. You have to then support her everyday needs, or give her additional money in distribution of your assets because you're still married. If she can't move on, then you have to help her live her day-to-day life. It's actually a kind of logical progression and process. If she can't move on and you're still married, then you have financial responsibilities to one another.
Yeah, I mean, as a person who advocates for the giving of the get, I think it makes perfect sense. And actually, when we had Melissa researching this issues to find the cases where get refusal was properly upheld as a way to consider it when deciding maintenance and equitable distribution, that's exactly what the court said in some cases, is that they found that the wife, by being denied the religious divorce, was going to suffer economically and socially, which can circular have an economic impact, but they found that the sufferings of that spouse deserved economic compensation. And when you deal with things like financial maintenance and you deal with the property distribution, the courts can take into account really any factor that they think is fair. They're guided by this principle called equity, what feels right. And it does, they say like this person is going to be denied a dual income household. This person can be denied maybe social opportunities. This person is also going to lose out on the emotional support of a spouse, which we felt was kind of similar to this principle in law called consortium. When you lose a spouse, let's say in an accident, you might be entitled to certain financial compensation. So it is basing this on these civil principles. But there's also cases, there is especially one case that I can think of that's pretty recent, where the court said that the husband was refusing not to provide the get because of a financial opportunity that he was looking for. He wasn't trying to use the get as leverage to concede some concession from the wife. He did not feel like he needed to be going to a basin if his wife chose a secular court. And religiously, he didn't think he had the obligation to provide a get. And the court said, we're not touching this issue. It's too religiously intertwined. We're not dealing with it. We're not going to consider get refusal in our decision, because he's saying he has a religious reason for not doing it, not a financial reason. So, that's a more recent decision. It came out in 2017, and we'll see where the courts land on it. But I think Rachel's point is correct. For the most part, these are civil principles that the court, I think, will uphold, but you never know. There's no guarantees.
Right, but what's important to notice, though, in that decision, in that 2017 decision, is the fact pattern, the specific fact pattern. So the fact pattern is very specific, and the way that a judge crafts his or her decision is also very important. The language that's used in there. When a judge stays away from the religious issue and focuses on the financial implications, it's very different. And so it's also really very important that the attorney that represents you in these cases, in civil court or in Basin, and yes, an attorney can and should represent you when you're going through a Basin process as well. It's very important for them to be educated and to know the system well, to know the ins and the outs, and know how things should be presented, how an argument should be made, so that when decisions are made by the courts, they take into account these issues in a way that it's framed to work for you.
Yeah, that is an excellent point. Having an attorney who knows what facts and what questions to ask during trial to make the record to show the get is being refused as usually certain types of leverage or punishment or spite, it's not being refused on some religious ground. That is a very important thing to establish in your record. And the most successful cases had that record. Rabbis testifying, the witness testifying to that. And that was what made those cases successful.
And then we see decisions where women are given more money and support, where more equity in a house or even an entire house was given to a woman who was refused a get. So judges do consider these arguments carefully and make decisions accordingly.
So I'm going to stop the slides for a minute because I want to just have a very brief discussion. I know we're running towards the end of the time as to, what can the community be doing and why is the community so important? So Rachel, what do you think about this?
Absolutely. So we've discussed the court processes and the based-in processes, but we see that it's not working. Okay. Often it does, but we know of so many cases of Agunot, of women who are chained for quite a long time, who are unable to get their get. And so the question is, we know that it's happened. How do we fix it? How do we get them free? How do we solve this problem for them? And, we're not talking about prevention at the moment, although, it all kind of ties together. But I think the answer there, and you and I have discussed this frequently, is community involvement, community pressure, community involvement. And, it's really about the community sending a message that get refusal is not okay. Get refusal is abuse, period. There aren't two sides to the story. It is abuse. It is one party using leverage against the other. It is one party who has a tool that they can use for leverage where the other does not have that. The other does not have that remedy. The playing field is not level. And the only way to level that is by giving that get. And so if there's a communal shift and if there's communal pressure, that's how we effectuate change. Which brings me back to, how we opened our discussion tonight, talking about the students in high school acknowledging that get refusal is in fact abuse, and that coming to mind immediately for them. That means we're on the path to community change and to a shift in thinking. We're not there yet, okay? There's so much work to be done and so much more support that's needed and more advocacy that's needed, but I'm encouraged that we're on the path to get there. But it's really, you're going to see more change through community efforts than even the courts. And I'm saying that, as an attorney that does this day in, day out, we see settlement of cases through communal involvement more so than through judicial intervention. Do you see the same?
I think ultimately, when it comes down to it, if a spouse is afraid of how their family or the community will react if they do not provide the get will be provided. It should be, a lot of my cases, thankfully the get is eventually provided, but all the way at the end of the case. And my client has to suffer years of litigation not knowing what's going to happen, wondering if her decision to do this in custody or her decision to doing this in child support is going to come back and bite her, because then her husband, who is usually unpredictable, might take it the wrong way and then say, I'm going to get you back for that. If you pursue your right to child support, I'm going to get you back, even if you're not asking for severance, even if you're asking for a penny more than what they're going to get under the guidelines, being like, nope, I don't like it. I don't think I could afford that. You have to take less than what the law will give you if you want your get. So litigating that way is extremely stressful. And a lot, I think, in the community does shield that kind of behavior, saying, you know what, they can wait until the end of the case to get their get, because why do they need it now if they're not planning on remarrying anyways? Like, what do they need it for? And that's really a common response I get. I think the community needs to do more pressure to say the get needs to be given up front, so both parties feel like they can lawfully pursue their rights under what the laws say. I think if someone feels shame in their actions, they're more likely to provide and rectify the behavior. They don't want to be embarrassed in their synagogue. They don't want to be embarrassed among their family. And that is power that can not come from the law. It can only come from the neighbors, friends, religious leaders. And it's important to make the religious leaders know that this is something, that we want done. What I've been encouraged about by the social media movement on the Get is the amount of passion that people are bringing to the table. This is something that makes them angry. It's something that they don't want to stand for anymore. And I think, we kind of need to ride that wave if we want to see real change.
Absolutely, absolutely. I couldn't agree more. That's why we felt it was so important for us to do this webinar tonight, to explain a little bit more about the process so that people are more in the know. The more, more knowledgeable people are, the more empowered they feel in this process. And I hope that we've achieved that. So the only thing that we can ask is that all of you watching tonight really join in helping Agunot, in supporting them, and in putting pressure on the community to make this change, this important change, to free these women and men too who are in these situations, but women for the most part. So Erin, I want to thank you for, again, a fabulous and informative, important presentation tonight. I see that you've now put up the Sarah's Voice contact information, so I'll pass that back to you.
Yes, I know we didn't really have too much time to do questions, but I've seen that there's some questions that came in, there's some comments. I just want to say, if you have a legal question about the Get or about your situation, Sarah's Voice provides free legal services. We don't charge anything. We do advice and consultations. So if you, there's several ways to get in touch with us. If you want to talk to someone anonymously or confidentially, you can call the Shalom Task Force hotline. The hotline number is confidential and anonymous, so they won't know that it's you who's calling.
And chat, we have a chat line now
as well, which my understanding is it's not us, but it is confidential. So everything you say to anyone from our organization will be kept within the organization. It is protected. No one's going to say anything. We respect the community's privacy. So these are and if you want to get more information just about the general work that we do, the slides and this recording of this presentation will be put up on the website. If there's anyone that who can attend tonight that would be interested in this topic, please share. And I'm going to leave. Thank you for joining us, and I'm going to leave the final word to you, Rachel.
That's it. You got it. We are here for you. We are here to support you. We understand what you're going through. Reach out. We'd love to help you. Have a good night.
Thank you, everyone.